What is needed to stop someone? Issues involved in stopping someone. Introduction. An officer needs reasonable suspicion to stop someone. The following case, involving an officer stopping a person to ask for ID, provides a good introduction to reasonable suspicion. Later on, when we get to vehicle stops, we will further discuss the issue of asking people for ID. Stop, ID request. Facts. An officer was in a neighborhood well known for drug trafficking. Two male subjects were standing in an alley, a few feet apart. When the subjects observed the police vehicle, the two male subjects walked in different directions. The officer stopped one of the male subjects because the situation looked suspicious. The officer had never seen that subject in the area before. The subject became angry and refused to give the officer any identification. He was arrested for concealing ID. Was the officer correct in arresting the citizen for concealing ID? No. Answer. This case came from the United States Supreme Court. The officer had a right to talk to defendant and ask for identification. But when the defendant didn't want to give the officer his identification, and wanted to leave, it became a stop. He was being detained. The problem is that the officer lacked reasonable suspicion to believe the defendant had been or was involved in criminal contact. The stop, once it became non-consensual, and given the absence of reasonable suspicion, was unlawful. Brown v. Texas, 1979. Recommendation: if we stop someone to talk to them, and they're free to leave, we need to make this clear to the court. Stop means not free to leave. More helpful words to assist the court might be: approach, free to leave; made contact, free to leave; consensual encounter, free to leave. You're an officer on the witness stand. How would you answer the following questions? Officer, could we agree that you stopped my client because you had a hunch he was involved in criminal activity? No. Officer, would it be fair to say that you stopped my client because you had a gut feeling she had just committed a crime? No. Officer, isn't it true that you stopped my client because you felt things looked suspicious? No. Many officers use these words as if they had the same meaning. Unfortunately, if you answered yes to any of the above, it may mean dismissal of the case. Reminder: the legal standard to stop someone is reasonable suspicion. Anything less, a hunch, a gut feeling, it looked suspicious, is not enough. The important thing is to articulate, go into detail, why you made a stop. Seizure, free to leave. Facts: at approximately 7 p.m., an officer in Clovis was called to a possible domestic in progress. The dispatcher said the caller wanted to have Joshua Garcia removed from the residence. As the officer got to the intersection nearest to the residence, he saw a man, defendant Joshua Garcia, walking across the street. The officer didn't know defendant nor had a description been given of him. He shone his spotlight on defendant, got out of his patrol car, and told defendant to stop. Defendant continued walking. Pepper spray was used and defendant dropped some crack cocaine to the ground. Will the cocaine be admissible as evidence? No. State v. Garcia, 2009. Answer: under these facts, there was no indication a crime had been committed. Walking in the vicinity of the location where the call came from is not reasonable suspicion. Nor is the time of day, 7 p.m., an unusual time to be walking. Supreme Court held there was no reasonable suspicion and ordered the drugs suppressed. Reminder: a person is seized if he or she is not free to leave. An officer can seize, detain, a person if there is reasonable suspicion that the person detained is breaking or has broken the law. In this instance, when the defendant was told to stop, he had been seized without reasonable suspicion. Recommendation: in a situation like this, officer can have a consensual encounter with the defendant, permitting him or her the freedom to leave. Concealing ID, obstructing facts. Roswell police were advised that a vehicle not belonging to anyone in the neighborhood had been parked in front of a house for 30 minutes. It was late at night, 11:30 p.m., when an officer observed two males in the vehicle. Because of recent burglaries, he asked both people for ID. The driver was cooperative. The passenger gave his name and address but refused to give the officer his ID. He was charged with obstructing. State v. Hudson, 2007. Was the officer correct arresting the passenger for obstructing? No. Answer: the officer had a generalized suspicion about the situation. But he didn't have an individualized reasonable suspicion that defendant was committing or had committed a crime. The two subjects were sitting in a car, legally parked, and not involved in any criminal activity. In a situation like this, where the individual refuses to provide identification, and no individualized reasonable suspicion exists, that's the end of the story. We cannot charge concealing ID or obstructing an officer. Conviction reversed. News item: woman arrested by APD awarded $65,000. Albuquerque police were dispatched to a lady's home to investigate the complaint of a tow truck driver who said her son had driven a repossessed vehicle away and caused $4,000 damage. The officer asked the lady for her son's birthday and she said she didn't know. The officer, believing her to be evasive, asked for her ID. When she didn't produce it, she was arrested for concealing ID. The 10th Circuit Court said there was no probable cause for the arrest. The federal jury awarded $65,000 in damages. The city will also pay legal fees. Albuquerque Journal, January 30, 2009. Reasonable suspicion, flight facts: in Albuquerque, an individual sold drugs to an undercover officer. Defendant was among a group of 8 to 10 people standing nearby. When members of the arrest team arrived, the defendant took off running. After numerous commands, he stopped. He threw crack cocaine underneath a car. Does his sudden running and being near a drug transaction support reasonable suspicion for a stop? If not, the drugs will be inadmissible. State v. Harbison, 2007. Answer: an individual walking away from a police officer, when there is no suspicion of a crime, can do so. He is going about his business. But running, an unprovoked flight, is not going about one's business. In fact, it's just the opposite. Supreme Court of New Mexico held that defendant's presence near a drug transaction, combined with his unprovoked flight upon noticing police, supported reasonable suspicion for an investigatory stop. The stop being valid, the evidence seized was admissible. What is needed to frisk someone? Issues involved in stop and frisk. Introduction: in this section, we will look at a number of cases. If a pat-down is good, the evidence will be admissible. If not, the evidence will be inadmissible. And one thing comes through in these cases, loud and clear: the extraordinary importance of articulating why we do what we do. Facts: Terry v. Ohio, 1968. One of the most famous cases in American legal history. Stop and frisk, a pat-down, a Terry stop, it's all the same thing. It's mid-afternoon. A police officer is standing across the street from a jewelry store. He watches two men walk up to the jewelry store, look in, and continue walking. They come back and look in again. They do this about a dozen times. Soon they talk to a third man. The officer believes a robbery is about to take place. He confronts them and asks for ID. They are wearing heavy, out-of-season jackets. When one starts mumbling, he pats them down. On Terry he finds a handgun. Terry v. Ohio, 1968. The stop: a Terry stop is a seizure where someone is stopped and not free to leave. To do a Terry stop or pat down, Fourth Amendment guidelines must be followed. The legal standard for a Terry stop is reasonable suspicion. If an officer is able to articulate facts to support reasonable suspicion, this will be a good stop. The frisk: a stop and a frisk is a two-step process. The justification for the stop may not justify a frisk. A frisk is a search for weapons. If the officer is able to articulate facts to support reasonable suspicion the person is armed and dangerous, this will be a good frisk. Are we able to articulate facts to support a stop? Yes. A pat down? Yes. Answer: the facts support reasonable suspicion for a stop. 1. Going back and forth and looking. Inside a jewelry store window. This suggests the three subjects are waiting for the cashier to be alone so that they can rob him or her. 2. The heavy out-of-season coats. These likely contain pockets to carry stolen jewelry. The facts also support reasonable suspicion for a pat-down. 1. A possible robbery which is a violent crime. 2. The subjects wore heavy coats which can hide weapons. 3.